Good morning. I'm Gary DeWaal, and this is Bridging the Week for December 19, 2016 through January 6, 2017, and today is January 9, 2017. More than 5 years after the collapse of MF Global Inc., a well-known Futures Commission merchant that prevented the repayment to customers of 100% of their funds for over 2.5 years, John Corzine, the firm's former chief executive officer, settled a disciplinary action brought by the Commodity Futures Trading Commission for his role in the firm's collapse by payment of a $5 million fine and a CFTC registration prohibition. Although Mr. Corzine was required to pay this fine out of his own pocket and not through insurance, he was not required to admit to any of the substantive allegations in the CFTC's original 2013 complaint against him or in the consent order that formally resolved this disciplinary action. Separately, 3 non-U.S. persons were criminally indicted and sued by the Securities and Exchange Commission at the end of 2016 for allegedly illicitly infiltrating the email of 2 law firms, obtaining non-public information regarding pending mergers and acquisitions, and trading for their advantage on such information. I hope everyone had a restful holiday season. Beginning this version, the video version of Bridging the Week will be solely a high-level summary of the major articles appearing in the article version of Bridging the Week each Monday. To give you an idea of what will be like, let's get started. As mentioned, last week John Corzine settled charges brought by the Commodity Futures Trading Commission over his alleged role in the collapse of MF Global Inc. in 2011. He agreed to pay a fine of $5 million and to various prohibitions against associating with the Futures Commission merchant or registering with the CFTC in the future. In addition, Ms. Edith O'Brien, who was Assistant Treasurer of MF Global on the day of its collapse, also settled charges against her by agreeing to pay a fine of $500,000 and to various suspensions of her ability to associate with an FCM for 18 months. Folks will be debating the appropriateness of Mr. Corzine's settlement for many years in light of the severity and implications of MF Global's collapse. At the end of last year, the U.S. Attorney's Office in New York City disclosed that criminal charges had, earlier in 2016, been filed against 3 non-U.S. persons in a federal court in New York City, claiming that they had hacked email of 2 unnamed law firms, illegally obtained emails regarding pending merger and acquisition transactions, and purchased and sold securities based on such illicitly obtained information. On the same day, the SEC filed a civil action against the same persons in the same federal court in New York City related to the same facts. As alleged in the criminal indictment and by the SEC, between April 2014 through late 2015, the 3 persons caused malware to be installed on the law firm's web servers that permitted unauthorized access to the firm's email. The defendants used this access to obtain the relevant email that contained the confidential information on which they traded. These allegations again remind us all there are likely only 2 types of businesses: those that have been subject to cyber attacks and are aware of it, and those that have been subject to cyber attacks and are not aware of it. Help ensure your business is not in the latter category. Marquette Partners agreed to pay a fine of $20,000 to resolve a disciplinary action brought by ICE Futures US because of an alleged malfunction in an automated trade system it operated from January 23rd through March 9th, 2015. During this time, on quote-unquote numerous occasions, Marquette's ATS allegedly entered orders in back months of cocoa futures, then rapidly deleted such orders and immediately placed new orders all within 1,000th of a second. Separately, the New York Mercantile Exchange summarily denied access to all CME Group markets to El Dorado Trading Group LLC for allegedly engaging in certain disruptive trading type activities on numerous dates beginning in December 2016. According to NYMEX, El Dorado would knowingly place trading at settlement orders in multiple products with incomplete and wrong information in the sender location field, gain queue priority when the trading at settlement market opened, then modified the problematic data to correct it. This conduct continued, said NYMEX, even after the exchange warned El Dorado to stop it on December 22nd, 2016. Two publicly traded companies agreed to settle Securities and Exchange Commission enforcement actions related to their use of separation agreements that the Commission claimed inhibited ex-employees from communicating with the SEC in violation of their whistleblower rights under federal law and SEC rule. Under this rule, no person can take any action, quote, to impede an individual from communicating directly with the Commission staff about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement with respect to such communication, end of quote. In both cases, the companies allegedly used confidentiality agreements that contain language contrary to regulatory requirements. It's worth reviewing your firm's severance agreements to assess whether they strictly comply with applicable SEC and CFTC rules. And finally, the Financial Industry Regulatory Authority assessed a total of $14.4 million in fines against 12 firms for quote-unquote significant deficiencies in their retention of required books and records in required electronic format. Generally, all principal international regulators have rules related to the generation and retention of records by registrants in the futures and securities industry. These rules typically describe the type of records that must be prepared in the first instance, how long and in what format such records must be retained, and to whom and in what time period such records must be produced when requested by an authorized regulator. Firms should have robust programs to ensure compliance with these requirements that include procedures to ensure that all required documents are saved and saved correctly, and that nothing goes amiss with the programs over time. Well, that's it for this edition of Bridging the Week. As always, there is more information in each article, and more articles in the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, a week from tomorrow, not next Monday, ciao.